But it's been a while since that was the court's only focus. I mean, Prosecutor Bensouda was the first one to take the court out of Africa when she started investigating in Georgia and then in Afghanistan. Um, those didn't at that time lead to any actual suspects, but under the current prosecutor, Prosecutor Khan, we have seen a much different emphasis by the Office of the Prosecutor. Now you have charges facing Vladimir Putin. You have charges facing Netanyahu and Gallant. In Israel, you have charges facing supreme leader of the Taliban in Afghanistan. You have at least the possibility of charges against the leaders of the junta in Myanmar. You have charges facing Rodrigo Duterte, who's actually in detention in The Hague, the former head of state of the Philippines. So
Powered by International Committee of the Red Cross.
Hello and welcome to Legally Speaking on DawnNews English. I'm your host, Ayesha Malik. In today's episode, we'll be talking about international criminal law and the International Criminal Court in particular. Now, the international criminal justice system has three core aims, which kind of mirror what the aims are of the domestic criminal justice system, which are to end impunity by punishing perpetrators through legal means. This can be trial, conviction, and punishment. To console the victims, either through vindication, reconciliation, or reparation, and also for juridical humanity, which is by giving conscience of mankind a form. Now, international law traditionally was generally addressed only to states. There was some domestic law which punished violations of the laws of war, such as the Liber Code, but it was not really addressed to individual violators. This changed somewhat after World War I, which had a renewed emphasis on individual responsibility. So the Treaty of Versailles had 4 articles providing for the punishment of those who had violated the laws and customs of war by the Allied military tribunals. However, no trials were ever held. The Treaty of Versailles did seek to prosecute the Kaiser of Germany, but he fled to the Netherlands and his surrender was not requested. The main aim of the Treaty of Versailles was to humiliate Germany. Fast forward to World War II, and after that, we had the Nuremberg trials and the Tokyo trials. So Britain initially did favor summary execution of major war criminals such as Hitler or Himmler on the basis that their guilt was so black that it was beyond the scope of any judicial process. In comparison, Stalin advocated for a special international tribunal for prosecuting Hitler, his close advisors, and senior military leaders. Similarly, the United States and France both preferred the establishment of an international tribunal to prosecute war crimes. There were several criticisms of this at the time, which was it was called high-tech lynching because it was one-sided, only the victors were trying the vanquished. Others argued that it was not plausible that any of them would be found not guilty. Their guilt was, in essence, predetermined. And also, it was fundamentally an ex post proceeding, in that it was the first time that you were saying that these offenses were actually crimes. It wasn't really codifying existing practice, but it was projecting what should become a crime. Now, there are several counters to this which justify the Nuremberg and Tokyo trials, which is that it was quite ridiculous to say that Nazi Germany did not know what they were doing at the time was wrong. And it can't really be an offense when the acts that they were committing were punishable under their own domestic law. Also, the intention to prosecute these crimes was announced by states at war with Germany, so some sense of notice was given. And in the Treaty of Versailles, the principle of personal responsibility had already been noted. Now, the International Military Tribunal for the Far East, which is called the Tokyo trials, also was further mired by politics. For instance, it did not prosecute the Japanese Emperor Hirohito as a war criminal because he had agreed to the unconditional surrender of Japan. Further, Filipino General Yamashita was held responsible for acts of his subordinates which he had not ordered and of which he was unaware. There were also many social distinctions between the trials in Germany and those in Japan. So unlike in Germany, where those accused and convicted of war crimes became, for the most part, pariahs in their society, the Japanese did not view such persons as criminals, but as victims. For the Japanese, the trials were victor's vengeance couched in terms of victor's justice. The Indian judge at the Tokyo trials, Justice Bull, he wrote a long dissent to his judgment. And he wrote that the tribunal was a sham employment of legal process for the satisfaction of a thirst of revenge. In his view, the atomic bombings of Hiroshima and Nagasaki were the worst crimes committed during the war, comparable with the Holocaust. He argued that Japan's purpose of going to war was largely dictated by security. At the end of the trial, Justice Ball's words were that the Tokyo trial was conducted by demagogues of wartime propaganda. He wrote that the purpose of the trial was to implicate Japan as responsible for all wrongdoings. He said that I would have never believed how such deceit has crushed the spirit of the Japanese people. The Tokyo trial has inflicted even greater damage than the atomic bomb. Nevertheless, after the Nuremberg trials and the Tokyo trials, there was this renewed emphasis on individual responsibility. A very famous quote from the Nuremberg trials was that crimes against international law are committed by men, not by abstract entities. And by abstract entities, they mean states. And only by punishing individuals who commit such crimes can the provisions of international law be enforced. Since then, we have had courts established by the UN Security Council under its Chapter 7 powers, which claimed that the establishment of these tribunals was required for international peace and security. This happened in the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda in the 1990s after those civil wars. In addition, we've had a number of hybrid tribunals, including the Special Court for Sierra Leone, the Extraordinary Chambers in the Courts of Cambodia, and the Special Tribunal for Lebanon. And since then, in 2002, with the entry into force of the Rome Statute, we also have the International Criminal Court, which is the only extant and permanent international criminal court to be established under a multilateral treaty. So while it is not a UN organ, it is in relationship with the UN. And it is deemed to have international legal personality in that it possesses legal capacity as necessary to exercise functions and fulfill its purposes. We will be talking a little bit more about the nature of the ICC's work and also the core crimes that come under the jurisdiction of the ICC, including genocide, crimes against humanity, war crimes, and aggression. It's important to also note that the ICC regime is premised on the principle of complementarity to national jurisdictions. In practice, this means that states can preempt ICC's prosecution or investigation by doing so themselves and doing it genuinely, as then the case becomes inadmissible before the ICC. This is part of how the legal system in which the ICC works, in that it aims to strike a balance between the primacy of state action in investigating and prosecuting international crimes, and it has to be the same conduct and it has to be done so genuinely, and the ability of the court to step in where states fail to act. In that, the court's jurisdiction can be trumped by national jurisdictions, and national criminal jurisdictions enjoy primacy over the ICC. Now, going back to the core crimes under the ICC, the court's jurisdiction, let's start off with the crime of genocide. Article 6 of the Rome Statute covers the crime of genocide, and the definition is itself lifted from the Genocide Convention of 1948. And it says that for the purposes of this statute, genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethnic, racial, religious group. And the acts listed are killing members of the group, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent births within the group, and forcibly transferring children of the group to another group. Now, the crime of genocide is at the core of the case between South Africa and Israel at the International Court of Justice, not at the ICC. We have not yet seen charges for genocide being laid against Netanyahu and Gallant, but the onus is on South Africa to prove that that special intent exists on the part of Israel, which is that intent to destroy the group. And that doesn't mean the intent to displace the group. It doesn't mean the intention to move out that group into another area. It means that very specific intent to destroy the group. Now, the second crime is that of the crime against humanity. Article 7 of the Rome Statute says that for the purposes of this statute, the crime against humanity means any of the following acts when committed as part of a widespread or systematic attack directed against any civilian population with knowledge of the attack. So this includes murder, extermination, enslavement, deportation or forcible transfer of population, imprisonment or other severe deprivation of physical liberty in violation of fundamental rules of international law. It also includes torture, rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, persecution against any group enforced disappearance of persons, the crime of apartheid, and other inhumane acts. Now, crimes against humanity can be committed in peacetime and in wartime, and the most important element required for that is that it is committed as part of a widespread or systematic attack which is directed against any civilian population with knowledge of that attack. Now, in Article 8, it covers war crimes, and there is a massive detailed definition in Article 8 of the ICC statute for international armed conflicts, the war crimes that can be committed in international armed conflicts, and then another list for internal conflicts. It is important to remember that not all violations of the laws of war are war crimes. Not giving a prisoner of war his tobacco ration is a violation of the laws of war, but it is not a war crime. Under the Geneva Conventions, it is grave breaches which are considered war crimes under international law, and they overlap with the Rome Statute, and only grave breaches are considered war crimes. So these include, for instance, the willful killing of civilians, torture or inhuman treatment of civilians, willfully causing great suffering or serious injury to body or health, extensive destruction and appropriation of property, not justified by military necessity and carried out unlawfully and wantonly, and the taking of hostages is also considered to be a war crime. Now, the common issues to all war crimes is that there must be an existence of the armed conflict, and there must be a nexus between the conduct and the armed conflict. Finally, the crime of aggression. For the purpose of the Rome Statute, the crime of aggression means the planning, preparation, initiation, or execution by a person in a position effectively to exercise control over or to direct the political or military action of a state of an act of aggression, which by its character, gravity, and scale constitutes a manifest violation of the Charter of the United Nations. Now, an act of aggression essentially means that there has been a use of force against another state's territory, and that use of force does not come under the exceptions outlined in the UN Charter, which are that of self-defense or of Security Council authorization. Now, those are the 4 core crimes under the jurisdiction of the court. And to talk to us a little bit more about the work of the ICC and the principle of complementarity, and also threats and allegations which have been made against Mossad and Israeli involvement against ICC prosecutors, we're going to be talking to Kevin Jon Heller. So to talk to us about this a little bit more, we have with us Kevin Jon Heller. Kevin Jon Heller is Professor of International Law and Security at the University of Copenhagen Center for Military Studies, and also served as the ICC Prosecutor's Special Advisor on War Crimes. Thank you so much for joining us today.
Thank you for having me.
So I wanted to start off by talking about the expose by the Middle East Eye, which just came out a few days ago, which detailed the threats against Karim Khan, the prosecutor of the International Criminal Court, and the threats against his career, his reputation, and the future of the court. Now, The Guardian also published previously similar threats against the former prosecutor, Fatou Bensouda. Do you think that these claims coming to light, does that help the court's image, or do you think it hurts it?
In a way, I think it actually helps the court's image. You don't try to bully an institution that you don't think has any importance or any effectivity or any legitimate chance of doing something that you're worried about. You know, if something is completely powerless, you just leave it alone. I think it does reflect the sense that this is a legitimate institution, an institution that is doing its job, and that if it does its job in the way that it should, that it poses a threat to the individuals and states or whomever that are behind these types of threats.
Yeah, and just as part of that article, it was interesting because the report reveals statements from Senator Lindsey Graham that the ICC was made for Africa and thugs like Putin, not for democracies like Israel. So how do you respond to critics that argue that the ICC disproportionately targets actors from the global south? I know that African leaders have even called it the International Caucasian Court for the fact that it goes after African leaders. Now that we see the ICC going after, for the first time in its history, an ally of the West, do you think that the global south should take back that claim, or do you think that that criticism is still valid?
Well, I think the claim just reflects an earlier era of the court's existence, Long before I was a special advisor, I wrote really extensively and very critically of the court's focus on Africa. I think it would be very hard to dispel the criticism that in its earliest days, the court disproportionately focused on Africa. But it's been a while since that was the court's only focus. I mean, Prosecutor Bensouda was the first one to take the court out of Africa when she started investigating in Georgia and then in Afghanistan. Those didn't at that time lead to any actual suspects, but under the current prosecutor, Prosecutor Khan, we have seen a much different emphasis by the Office of the Prosecutor. Now you have charges facing Vladimir Putin. You have charges facing Netanyahu and Gallant. In Israel, you have charges facing supreme leader of the Taliban in Afghanistan. You have at least the possibility of charges against the leaders of the junta in Myanmar. You have charges facing Rodrigo Duterte, who's actually in detention in The Hague, the former head of state of the Philippines. So has the court somehow only started to, well, let me say that again. Is the court now focusing solely on Western states? No, and we probably shouldn't be surprised that it isn't. But it isn't just focusing on Africa. It isn't just focusing on those states in the global South that were so concerned about the court not having a more global focus. So we have to see where all of these various cases go. They're all at the earliest stages, but I definitely think that in the current era, it would not be particularly accurate to say that this is a court that is just focusing on non-whites and states in the global South.
Yeah, and I think especially in the think tank that I worked at, we were very critical of having these brown faces in high places as ICC prosecutors role, even though we thought Fatih Bensouda did a fantastic job. Karim Khan, when he deprioritized American crimes in Afghanistan, we were a bit murky about that. But I definitely think that the Global South is now sitting up and paying attention more to the court and what it has to say, which I think is probably good in the future. One side that I come against the general opinion on this from Global South states is the issue of immunity. And we've seen a very different reaction from the West to the issuance of arrest warrants against Putin and Netanyahu. So while Biden said that those against Putin were justified, those against Netanyahu were not. Aside from the political aspect, what do you think about the arguments that Putin, Netanyahu, and Umar al-Bashir before him have immunity?
Obviously, this is a topic of significant academic debate. It's a topic of significant debate between states. Really, all I can say is that this is a non-issue for the ICC because the court has addressed the issue. We have, binding ruling by the appeals chamber that there is no head of state immunity before the ICC. And perhaps more importantly, on the ground, they've also held that states are obligated, if they're a member of the court, to fulfill their obligations of cooperation and arrest any head of state, even if they are sitting and would otherwise enjoy personal immunity. They're obligated to arrest them and surrender them to the court. So I understand the criticism. I am in some way, as an academic, sympathetic to the criticism, but the court has ruled on this issue. And so all states that are members of the court do have this legal obligation and have to execute arrest warrants.
So my final question kind of goes into that also a little bit, in the sense of, where do you see the field of international criminal law in 20 years? And do you think that we'll see more in the form of universal jurisdiction? We've seen some European states, especially when it comes to war crimes in Syria, use that notion of universal jurisdiction to charge and prosecute people on their territory. Do you think that that's where we see the exercise of international criminal justice in the future? Or do you think that international criminal tribunals and courts, especially with the ICC being extant, that's the future vehicle through which we'll see international criminal justice?
Well, I mean, I hope it's not a simple binary choice.
Yeah.
I think there will always be a role for international tribunals, particularly the ICC. There are certain kinds of cases that states simply cannot handle themselves. And of course, that's the original motivation for international criminal law in general. We couldn't expect Germany to prosecute its own war criminals, and there really wasn't any well-established tradition of universal jurisdiction back then. So it was either an international tribunal, like we saw at Nuremberg, or nothing. We do have universal jurisdiction today, but there are still cases that are just too difficult for states to handle. And so I think we'll always have to have some kind of mechanism like the ICC to deal with those cases. And I don't think the ICC will disappear over the next couple of decades, but we have to acknowledge the limitations of the court. Even in the best of times, the court is under-resourced, understaffed, underfinanced. It can only prosecute a very small number of perpetrators in a very small number of situations. It cannot be the court of first resort. And it's not designed to be. It's designed to be the court of last resort. It's designed to promote states taking the lead in conducting prosecutions of international crimes. So I've been saying for a very long time, and I'm certainly not the only person who's been saying this, that if international criminal justice is really to fulfill its promise, it's not going to be through international tribunals like the ICC. It will be through states stepping up and taking the lead in these prosecutions, primarily, although not always, but primarily through universal jurisdiction. There is universal jurisdiction over any of the core international crimes. Not all states make universal jurisdiction available, but I think easily more than 100, 120 do for at least some types of international crimes. As you said, we have seen states conducting prosecution of high-level, usually former government officials via universal jurisdiction, and we need more of that. We need states to take the lead in using universal jurisdiction. But more importantly, I think it's extremely important for states that are not in the West to start using universal jurisdiction. And in that sense, the kind of earlier stage of proceedings in Argentina is a really encouraging development. Normally, I'm just always the bearer of bad news with international criminal justice. So I try to focus on happier things. And if you're looking for a precedent that really is encouraging, you can go back to the Habre trial, where you have one African country using universal jurisdiction to prosecute the former head of state of another African country. That is a remarkable development, and hopefully, and to some extent already is, a blueprint for future prosecutions. So I don't think we have to choose, but I do think that the lion's share of responsibility has to be adopted by or taken by states.
Okay, so I wanted to follow up on that and ask about the principle of complementarity and whether you think that that will be a role that states will fulfill in meeting the gap where the International Criminal Court won't have to act and where they would want the ICC to not act.
I mean, the problem with the way you ask the question is that complementarity, I mean, we do have the notion of positive complementarity, and the office puts a lot of stock on encouraging states to do prosecutions. But really, complementarity is a check on what states want to do. States are trying to invoke complementarity to avoid, being investigated and prosecuted by the ICC, Israel being the most obvious example of that. And it's in that context where I think not just ordinary people, but most journalists, not present company accepted, don't understand how complementarity works. So if maybe you want to, I can give you both sides of that answer, the positive and the negative complementarity, or I can focus on whatever you want. But I think it's really important for people to understand why Israel's complementarity claims are simply just not recognizable by the court, because they don't. Someone like Lindsey Graham has no understanding of complementarity at all.
Yeah, definitely. Yeah. So let me just ask a very general question then about how you see the principle of complementarity going forward among states and how they interact with the ICC.
Well, I think there are two aspects to this. The first is what we call positive complementarity, and that's the role that the Office of the Prosecutor at the ICC plays in encouraging states to take the lead in these prosecutions. This particular prosecutor is deeply committed to complementarity. He wants the office to be what he's often called a hub of international criminal justice, helping facilitate the flow of information between states to facilitate prosecutions, flows of information from the court to states to help them conduct prosecutions. That's an incredibly important aspect of complementarity. The other aspect of complementarity, of course, is, I guess, what we could call negative complementarity, which is the role that complementarity plays in making sure that if states are going to take the lead in investigating and prosecuting, that they do so genuinely with the intent to actually convict a suspect. There is a long and boring history of skirmishes over how complementarity works. But I think particularly in the context of Palestine, we have seen gross misrepresentations of what the principle of complementarity means. The principle is actually very straightforward. If a state wants to conduct its own investigation or prosecution of a suspect that is wanted by the court, it has to do two things. It has to focus on the same perpetrator. You can't say, oh, we're going to start with somebody else, but we'll eventually get around to the perpetrator that the ICC is interested in. And they have to investigate or prosecute that same perpetrator for, the expression is, substantially the same conduct. Doesn't mean that conduct has to be exactly the same. A state doesn't necessarily have to use exactly the same charges that the ICC would, but they have to investigate or prosecute substantially the same conduct that the ICC is investigating for that particular perpetrator. Anything else, the case is still admissible at the court. So it's not enough to investigate other suspects. It's not enough to bring other types of charges based on other types of conduct against the same suspect. Has to be same suspect, substantially the same conduct. And the flip side of that is that when the court says that a case is admissible, this is not passing judgment on the quality of a judicial system in a state. It's not passing judgment on whether that state is a democracy or an authoritarian government. None of that has any relevance to complementarity. It is simply, are you investigating the same suspect for substantially the same conduct? End of story.
Yeah. Thank you for tuning in to this episode of Legally Speaking. We hope you enjoyed the discussion with Kevin Jon Heller and about international criminal law. And please tune in next week for future episodes.
Powered by International Committee of the Red Cross.